Hi, so would you please state your name and profession?
My name is Daniel Sokol. I'm a professor of law and business at the University of Southern California.
And why did you specialize in antitrust law?
A few years ago, I felt like I was living almost a monastic life, looking at some documents that very few other people did, really getting into almost a trance of excitement and almost religious fervor about a field that was really complicated and interesting. Since that time, we've gone mainstream. No one used to care about what I did. Now everyone seems to care. Many of them don't understand it, but they all seem to care. I went from being a nobody to being a somebody.
So that's what antitrust can do to you.
Apparently, yes. But why do you focus on it? In another sense, these are really fundamental questions about how do we organize business behavior in society. And competition matters, and it has real impacts on business and on end consumers.
Now, talking about consumers and their data, in the EU, we've been discussing issues at the intersection of antitrust law and data protection law for a while. What is the current US perspective on these issues?
I think it's evolving. I think historically it's that these were two complementary areas. I think in certain circumstances that's still the case. In other areas, we're seeing that they may be at odds. And yet in other areas, we think that sometimes they may be substitutable. But again, this is all changing politically. This is all changing with regards to both private and government enforcement, and potentially with legislation at the national level. We've already seen some legislation at the state level, such as more enforcement of privacy. We've seen much more concern on the part of companies as measured by publicly traded companies' disclosures with regards to their securities filings. Both competition and privacy matter. How much do they matter in terms of the intersection, I think, is a moving target.
Which word, and one word only, best describes the antitrust issues that we face in digital markets?
Complex.
And speaking of complexity, what is the one thing that every antitrust lawyer in Europe should know about US antitrust law?
At least under the current system, and again, with that caveat that the current system may change, we marry some kind of evidentiary-based analysis focused on economics with administrability concerns. So there is a common law evolution of US antitrust law, and antitrust responds to developments in our economic thinking, but it also very much evolves, in sort of a broader context of administrability, of when can we use these tools, to what effect, and specifically, can we create legal rules that best reflect a way forward that is not overly burdensome, but that can reach potentially anti-competitive behavior.
Wonderful. So it was great talking to you. Thank you so much.
Thank you.